This is Barry Zalma speaking for Zalma on Insurance. Today we're going to talk about why there is and should never be coverage for intentional acts, and when harm is inherent in the nature of the act, the court will always find that the act was intentional. And in this case, hitting a person in the face is an intentional act. In Unitrin Auto and Home Insurance Company versus Brian C. Sullivan et al., the Supreme Court of New York Second Department, that's their trial court, on November 19, 2025, dealt with the suit of George A. Ciminello, who was injured when struck in the face by a cup filled with liquid thrown from a moving vehicle operated by Brian Sullivan and Robert Harford as the passenger who threw the cup. The vehicle approached Ciminello at about 30 miles an hour from 2 to 10 feet away, and Harford extended his arm to make contact, and the cup splintered upon impact. Ciminello sued Sullivan and Harford, among others, in Supreme Court, Suffolk County, alleging intentional torts, willful, wanton, and intentional acts. Sullivan and Harford later conceded liability on the intentional tort claim before a damages trial. Unitrin Auto and Home Insurance Company insured Sullivan. The policy covered occurrences interpreted by the policy as accidents. Declaratory action, judgment action, Unitrin sued Sullivan, Harford, and Ciminello, seeking a declaration of no duty to indemnify Sullivan, arguing the incident was intentional, not an accident. Sullivan and Harford defaulted. They failed to appear or answer, and Unitrin moved for summary judgment in 2015. That summary judgment was granted in 2016, but reversed on appeal in 2020, finding a triable issue on whether harm was inherent in the act. A non-jury trial held on whether the incident was the accident, and the trial court ruled on March 1 of 2022 that it was not an accident and declared no indemnification obligations. Ciminello appealed, and the Appellate Division, Second Department, affirmed on November 19 of 2025. Sullivan testified he and Harford planned to fill a cup with liquid and throw it at somebody. They executed the plan intentionally. Post-incident reactions by Sullivan and Harford indicated the contact was not unintentional, but was in fact their intent. An insurer must indemnify only if the insured is liable for a covered loss under the policy. Here, coverage required an occurrence, meaning an accident, and there was none. Viewed from the insured's perspective, an accident is something unexpected, unusual, and unforeseen. Accidental results can stem from intentional acts if the harm was unintentional. If harm is, quote, inherent in the nature of the intentional act, close quote, the act is deemed to have intentionally caused the harm, negating any accident status. The court found the harm, facial injury from close range and throw of the cup, was inherent in the planned result. As the party seeking declaratory relief, Unitrin bore the burden to prove no coverage and met its burden. The intentional planning, execution, and inherent risk of harm meant the incident was not an accident, relieving Unitrin of indemnification duties under the policy, and the judgment was affirmed with costs. In my opinion, when Sullivan testified, he and Harford planned to fill a cup with liquid and throw it at just somebody, and fulfilled their plan. That caused damage to Ciminello. They admitted there was no occurrence as defined by the policy, and the court concluded that the insurer had no obligation to defend or indemnify Sullivan and or Harford, who managed to avoid arrest for battery, a felony. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe to the blog and to the videos on YouTube and rumble.com. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.